Why adjustment of status denials are rising in 2025. Imagine this. You've waited years, maybe even decades, for your chance to finally apply for a green card through adjustment of status. You send in your forms, pay the filing fee, and wait anxiously. But one letter from USCIS changes everything. Instead of an approval, you get a denial, and suddenly, you're facing deportation proceedings. This isn't just a nightmare for a few unlucky applicants. It's the reality many families are living through right now in 2025. Stricter review of marriage-based applications. One of the biggest areas where denials are happening is marriage-based green card applications. In the past, submitting a handful of photos and a joint bank account might have been enough to prove your marriage was genuine. But under current USCIS practice, officers are demanding much more. Couples are now expected to provide extensive evidence. Things like leases, joint taxes, utility bills, insurance policies, and even affidavits from friends and family. If your evidence is thin, the officer may conclude the marriage isn't in good faith. That's enough for a denial, and for people without lawful status, it can mean a fast track to immigration court. The risk of overlooking old removal orders. Another hidden trap involves past immigration history. Many applicants don't realize they were once placed into removal proceedings, often as children when their parents filed asylum applications or other petitions. If a family's asylum was denied, those children might have been automatically included in the deportation order, even if they were too young to remember. Fast forward 10 or 20 years, and that old removal order can come back to block a green card application. For this reason, immigration attorneys are urging applicants to file Freedom of Information Act (FOIA) requests to uncover any past records before submitting adjustment paperwork. Errors, omissions, and missing signatures. Believe it or not, one of the most common reasons for denial is something as simple as forgetting a signature or leaving out a required page. In the past, USCIS usually issued a request for evidence, RFE, to fix minor mistakes. But now, officers are instructed that they don't have to issue an RFE before denying an application. That means a missing signature, an outdated form version, or even a blurry copy of a supporting document could result in a complete denial. For families who spent thousands of dollars on fees, this is devastating, and the case can quickly shift from an application process to a deportation defense. Employment and financial-related problems. A major stumbling block for many applicants is the Affidavit of Support. This legally binding document proves that the U.S. petitioner or sponsor has enough income or assets to support the immigrant. USCIS has been cracking down hard on any perceived weaknesses in these forms. Even minor inconsistencies, like mismatched tax information, missing W-2s, or insufficient income, can result in a denial. Some families try to respond on their own, only to realize later that their explanation didn't satisfy the officer. At that point, it's too late. Many attorneys warn that failing to get professional help on this part of the process is one of the costliest mistakes people make. Criminal records and security checks. Another major issue arises when an applicant has any kind of criminal history, even minor charges from years ago. USCIS has access to extensive databases and will often request fingerprints from the FBI and Department of Homeland Security. In some cases, applicants have old arrests or charges they didn't even know were on their record. Something as small as a dismissed shoplifting case can still cause complications. For people with prior deportation or immigration violations, the consequences can be much worse. Some applicants have even been detained at their green card interview after their criminal history came to light. The impact of policy shifts in 2025. One of the most challenging aspects for applicants is that the rules keep shifting. Under recent guidance, USCIS officers have been given more discretion to deny cases outright instead of giving applicants a chance to fix errors. This is part of a broader effort to tighten immigration enforcement and reduce frivolous filings. Unfortunately, it often sweeps up legitimate applicants who made minor mistakes. The political climate in 2025 has also created additional hurdles, with more aggressive enforcement policies and closer scrutiny of certain visa categories. The danger of relying on preference categories. Many people mistakenly believe that if they have an approved family petition, they can automatically apply for adjustment of status. But this only works for immediate relatives of U.S. citizens, such as spouses, unmarried children under 21, or parents. For everyone else, including siblings and adult children, having an approved petition doesn't mean you can stay in the U.S. while waiting for your priority date. If you file too early or after falling out of lawful status, your case will almost certainly be denied. This is one of the biggest misunderstandings leading to denials in 2025. No second chances with USCIS denials. What makes the situation even riskier is that once USCIS denies your application, they can immediately refer your case to immigration court. Under current policy, USCIS doesn't have to issue warnings or notices before doing so. For many families, this means years of waiting for a court date, thousands of dollars in legal fees, and the emotional burden of deportation proceedings. For families navigating this system, the emotional toll can be overwhelming. It's not just paperwork. It's the fear of separation, the uncertainty of waiting, and the constant worry that one small mistake could tear everything apart. Behind every denied application is a family living in limbo, trying to hold on to the hope that one day they'll be allowed to stay together in the country they now call home. Steps you can take to protect yourself. The good news is that applicants do have options. Filing a FOIA request before applying can reveal any hidden immigration history. Working with an experienced attorney can help avoid critical mistakes, especially with the affidavit of support and criminal background issues. Double and triple checking applications before filing is also essential. While no one can guarantee approval, being thorough and proactive gives you the best possible chance. Why professional guidance matters. Many applicants underestimate how technical and unforgiving the adjustment of status process has become. What might seem like a minor mistake, such as incomplete evidence of marriage or a missing signature, can now mean the difference between approval and deportation proceedings. Having the right legal guidance early on can save years of stress, protect your future, and keep your American dream alive. Conclusion. Adjustment of status is one of the most important immigration processes in the United States. But in 2025, it has become more complex and unforgiving than ever before. Whether it's missing documents, insufficient evidence, or overlooked immigration history, small issues can have enormous consequences. If you're applying, prepare carefully, seek professional guidance when needed, and understand that a denial is not just a lost opportunity, it can also trigger removal proceedings. And as always, if you found this video helpful, don't forget to subscribe to Visa Intel USA, turn on notifications, and share this with others who may be going through the same process. We'll keep bringing you the latest updates and insights so you can stay one step ahead in your immigration journey.